The first addendum is commonly referred to as a general addendum and is the most problematic for licensees. The potential problems arise from all the blank lines you see on the form. Remember, licensees are only supposed to fill in blanks. The general addendum lends itself to more drafting of contractual verbiage than simply filling in blanks. Licensees are often tempted to draft extensive contractual provisions and place them on the general addendum. The general addendum was not meant to grant licensees the right to draft contracts. The division has approved a list of 16 standard supplementary clauses to be used on the general addendum. These are clauses which may be simply copied onto the form. If a licensee feels a transaction warrants further language than is available in the state-approved supplementary clauses, the services of a licensed and competent attorney should be engaged to properly draft the contractual terms. Otherwise, the contract may not protect the interests of the clients involved in the transaction. Lead-based paint disclosure. This form is not actually an addendum, but often leads to an addendum to the purchase contract. Federal law requires a lead-based paint disclosure be made to any buyer of any residence built before 1978. The lead-based paint disclosure, along with a special information booklet published by the federal government, satisfies this disclosure requirement. Sellers are not allowed to accept an offer on a home covered by the federal disclosure requirement until they have made the disclosure to the buyer. Once the disclosure has been made, the buyer has the option to perform additional testing for lead-based paint. If the buyer chooses to perform additional testing, a lead-based paint addendum must be completed and added to the contract. Lead-based paint addendum. This addendum outlines the buyer's rights in relation to additional inspections intended to identify the existence of lead-based paint. Let's review the specifics. Survey addendum. This addendum is used if the buyer wants the purchase contract contingent on the results of a survey. A survey is a report prepared by a licensed surveyor which describes the boundaries of a certain property. A survey defines the amount of ground included in a parcel and identifies any boundary line problems. For example, the legal boundaries of two adjacent properties may overlap due to incorrect legal descriptions. This would be considered a boundary line dispute. A fence may have been placed beyond a property line of a certain parcel. A survey should identify such a problem. The survey addendum, if accepted by both parties, grants the buyer a certain time period to have a survey performed on the property. If the survey reveals any discrepancies or problems with the property, the buyer may notify the seller in writing of their objections to information presented in the survey. The buyer and seller then have 7 calendar days to attempt to resolve the issues. If they are unable to resolve the issues, the buyer may cancel the contract within 3 days of the expiration of the 7th-day resolution period. If the buyer cancels a contract according to the provisions of the survey addendum, they are entitled to a full refund of their earnest money deposit. If the contract is not canceled, or no objections are raised in writing to the seller, the buyer is deemed to have waived their objection rights under the addendum. Seller financing addendum. A seller may offer to finance the purchase of a property on behalf of the buyer. In this case, the buyer does not obtain traditional financing, but the seller acts as the lender. Payments are made to the seller just as if they were the lender. The seller financing addendum first notifies the seller that the buyer is requesting the seller to finance the transaction. Second, the addendum sets forth the terms of the financing being requested by the buyer. Just like any other part of the contract, the terms set forth in the addendum are up to negotiation. Buyer financial information. As we mentioned, the seller financing addendum requires the buyer to disclose their financial information to the seller. This form may be used to satisfy the disclosure requirement. The buyer may also use another format for presenting the required information. FHA VA Addendum. If a buyer intends to use an FHA or VA loan to purchase a property, FHA and VA require certain clauses be present in the purchase contract. This addendum incorporates these required clauses. Assumption addendum. If a buyer wants to take over the loan currently held by the seller on the property rather than obtain their own financing, the buyer wants to assume the seller's loan. The assumption addendum outlines the terms of the current loan on the property and other terms of the assumption. Again, this addendum is incorporated into the terms of the real estate purchase contract. Real estate purchase contract for residential construction. The Division of Real Estate has approved a separate purchase contract to be used in the case of new residential construction.